Today on Legalese, we are discussing the cases of Lindke v. Freed and Oconner-ratcliffe v. Garnier. These are two cases that the Supreme Court announced on Friday, which create a new legal test for when a government official's social media posts are state action. Hey, greetings everybody, and welcome back once again to Legalese. So today we have the first wrap-up video of my Supreme Court Roundup series, and if you're new to my channel, if you're new to my channel, first of all, welcome. My name is Bob, and Legalese is a podcast where we're going to be discussing all things constitutional law, as well as current events in other areas of law, politics, and culture. Now, you can find out more about us by going and checking out our homepage over at legalesepodcast.com, where you can get show updates, contact me, buy my book, support the show, find past episodes, all kinds of stuff. And if you want to stay up to date whenever I post any new content, because I don't just do videos on YouTube, I write a lot of articles on Substack. I also do an audio-only version on Spotify. And if you want to get notifications for all of that, or even just get curated notifications whenever I post particular kinds of content, you can do either one of those things by going and subscribing to our newsletter over at legaleseshow.com. And so secondly, if you're new to my channel, the Supreme Court Roundup is a list of cases that I choose every term from the Supreme Court caseload that I find especially interesting or important for one reason or another, and we do a deep dive into every aspect of those cases every step of the way, from the facts of the case and the background to the procedural history, the oral arguments, and then finally the decision. And as you may have guessed, my wrap-up videos consist of us going through the final decision issued by the court in those cases that we have been following, and today is my first wrap-up video. Now, the Supreme Court has been noticeably and unusually slow in getting out opinions for this term, but that is what it is, I guess. So turning to my handy and dandy 2023-2024 term caseload list, the count is 3 cases whose oral arguments are still pending, although I think by the time this video gets out, Murthy and Vola will have been argued, but at least at time of recording, the count is 3 cases pending, 10 argued but not decided, and as last Friday, 2 decided. So that must mean that we are talking about Oconner-ratcliffe v. Garnier and Lindke v. Freed. Though you may have already guessed those were the cases we would be discussing today, based on the tiny hint that during my cold open I said, today we're going to be talking about Lindke v. Freed and Oconner-ratcliffe v. Garnier. Now, if you're asking why the title page only lists Lindke v. Freed, that will make perfect sense in just a minute, don't worry. So let's start with a quick refresher of what precisely these cases were even about. Now, both cases bear on when a government official's comment, deletion, or blocking decisions on social media may violate the First Amendment. Specifically, the issues with these cases was that they were actions being taken on an individual's ostensibly personal social media profile page. But the claims against them were that they used their personal pages to discuss information relevant to their government job, and that occasional usage made these pages examples of government speech, and their comment, deletion, and blocking was indeed a state action. Now, the Supreme Court on Friday would rule that public officials who post about topics relating to their work on their personal social media accounts are acting on behalf of the government, and therefore can be held liable for violating the First Amendment when they block their critics, but only when they have the power to speak on behalf of the state, and only when they're actually exercising that power. Now, the court's decision came from a pair of cases involving local officials in California and Michigan who blocked constituents who made repetitive and critical comments on their personal social media accounts. And This created a circuit split, which is what brought this case before the Supreme Court. So, in O'Connor-Ratcliffe v. Garnier, the U.S. Court of Appeals for the Ninth Circuit would rule that two school board members violated the First Amendment when they blocked two parents from their personal Facebook and Twitter accounts, which they used to provide information about the board and its work. The Court of Appeals reasoned that there was a close nexus between the trustees' use of their social media pages and their official positions, but in Lindke v. Freed, the U.S. Court of Appeals for the Sixth Circuit ruled that because James Freed, the Port Huron city manager, maintained his Facebook page on his own rather than as part of his job, he was not acting as a government official when he blocked a city resident, and there was therefore no First Amendment violation. Now, in a unanimous decision issued on Friday in Lindke v. Freed, an opinion written by Justice Amy Coney Barrett, the justices would send Freed's case back for another look. But Barrett would acknowledge that the question before the court was a difficult one, especially in a case involving a state or local official who routinely interacts with the public. She noted that although such official acts on the government's behalf were taken on behalf of the government, she reasoned that Freed did not relinquish his First Amendment rights when he became a city manager. Instead, she would explain, a government official's social media post can be attributed to the government only if the official has the authority to speak on behalf of the government and was exercising that power when he created the social media post at the center of the dispute. Now, in a case like Freed's, Barrett would continue, which involved a social media page with both personal and official posts. Making such a determination will require, quote, a fact-specific undertaking in which the post content and function are the most important considerations, end quote. Now, Barrett would also caution that the nature of the technology matters, and that it specifically matters when determining whether an official was acting on behalf of the government. Because although deleting comments allows an official to target only personal posts, blocking someone from a social media page that contains both personal and official posts could also prevent someone from commenting on official posts. She said, quote, a public official who fails to keep personal posts in a clearly designated personal account therefore exposes himself to greater potential liability. And in the decision in Oconner-Ratcliffe v. Garnier, what we had was just a brief, unsigned opinion that would follow Barrett's decision in the Freed case. And the justices essentially sent O'Connor-Ratcliffe back to the Ninth Circuit. They would vacate and remand and tell them to take another look at the case using the new test outlined in Lindke v. Freed. Now, heading back to the important decision, which was Justice Barrett's unanimous opinion in Lindke v. Freed, she would start by talking about how, like millions of Americans, James Freed maintained a Facebook account on which he posted about a wide range of topics, including his family and his job. She said, like most of those Americans, Freed occasionally received unwelcome comments on his posts. And in response, Freed took a step familiar to Facebook users when he deleted the comments and blocked those who made them. And Barry said for most people with a Facebook account, that would have been the end of it. But Kevin Lindke was one of the unwelcome commenters, and he would sue Freed for violating his right to free speech because the First Amendment binds only the government. But this claim, of course, is a non-starter if Freed posted as a private citizen. So the court found, however, that Freed is not only a private citizen, but also the city manager of Port Huron, Michigan. And while Freed insists that his Facebook account was strictly personal, Lindke would argue that Freed had acted in his official capacity when he silenced Lindke's speech. And turning to the text of the opinion, they say when a government official posts about job-related topics on social media, it can be difficult to tell whether the speech is official or private. We hold that such speech is attributable to the state only if the official, one, possessed actual authority to speak on the state's behalf, and two, purported to exercise that authority when he spoke on social media. Now, the court began with the familiar principle that the First Amendment applies only to government action and not a private individual's action. And there's very little controversy that social media pages run by government entities like a city council, school board, executive agency, and so on involve government action. But individual officials are both individuals and officials. So the question is which hat the person was wearing while running a social media page. And here is how the court would analyze this question. So they said that state or local officials who routinely interact with the public may look like they are always on the clock, making it tempting to characterize every encounter as part of the job. But while they can act on behalf of the state, they are also private citizens with their own constitutional rights. And by excluding from liability acts of officers in the ambit of their personal pursuits, the state action requirement protects a robust sphere of individual liberty for those who serve as public officials or employees. So, the dispute between Lindke and Freed would illustrate this dynamic. Freed, of course, did not relinquish his First Amendment rights when he became city manager. On the contrary, the court found the First Amendment protects a public employee's right in certain circumstances to speak as a citizen addressing matters of public concern. This right includes the ability to speak about information related to or learned through public employment, so long as the speech is not itself ordinarily within the scope of the employee's duties. Where the right exists, editorial control over speech and speakers on the public employee's properties or platforms is part and parcel of that. Thus, if Freed acted in his private capacity when he blocked Lindke and deleted his comments, he did not violate Lindke's First Amendment rights. Instead, he merely exercised his own. And so they go on to say that for the reasons we explained below, a public official's social media activity constitutes state action under Section 1983 only if the official, one, possessed actual authority to speak on the state's behalf, and two, purported to exercise that authority when he spoke on social media. The appearance and function of the social media activity, they say, are relevant at the second step, but they cannot make up for a lack of state authority at the first. They go on to talk about how the first prong of this test is grounded in the bedrock requirement that the conduct allegedly causing the deprivation of a federal right be fairly attributable to the state. An act is not attributable to the state unless it is traceable to the state's power or authority. When the challenged conduct entails functions and obligations in no way dependent on state authority, state action does not exist. Now, Lindke insists that Freed's social media activity would constitute state action because Freed's Facebook page looks and functions like an outlet for city updates and citizen concerns. But Freed's conduct is not attributable to the state unless he was possessed of state authority to post city updates and register citizens' concerns. If the state did not entrust Freed with these responsibilities, it cannot fairly be blamed for the way he discharged them. The court said that Lindke imagines that Freed can conjure the power of the state through his own efforts, yet the presence of state authority must be real and not a mirage. And importantly, Lindke must show more than Freed had some authority to communicate with residents on behalf of Port Huron. The alleged censorship must be connected to speech on a matter within Freed's bailiwick. For example, imagine Freed posted a list of local restaurants with health code violations and deleted snarky comments made by other users. If public health is not within the portfolio of the city manager, then neither the post nor the deletion would be traceable to Freed's state authority, because he had none. For state action to exist, that state must be responsible for the specific conduct of which the plaintiff complains, and there must be a tie between the official's authority and the gravamen of the plaintiff's complaint. And they talk about how Section 1983 lists the potential sources of official authority as such, quote, statute, ordinance, regulation, custom, or usage, end quote. Now, statutes, ordinances, and regulations refer to written law through which a state can authorize an official to speak on its behalf, while custom and usage encompass persistent practices of state officials that are so permanent and well settled that they carry the force of law. So the court goes on to say a city manager like Freed would be authorized to speak for the city if a written law, like an ordinance, empowered him to make official announcements. And he would also have that authority even in the absence of a written law if, for instance, prior city managers had purported to speak on its behalf and had been recognized to have that authority for so long that the manager's power to do so has become both permanent and well settled. And if an official has authority to speak for the state, he may have the authority to do so on social media, even if the law does not make that explicit. The court would say that determining the scope of an official's power requires careful attention to the relevant statute, ordinance, regulation, custom, or usage. That in some cases, a grant of authority over a particular subject matter may reasonably encompass authority to speak about it officially. For example, a state law may grant a high ranking official, like the director of the State Department of Transportation, a broad responsibility for the state highway system that in context includes authority to make official announcements on that subject. But at the same time, courts must not rely on excessively broad job descriptions to conclude that a government employee is authorized to speak for the state. The inquiry is not whether making official announcements could fit within the job description. It is whether making official announcements is actually part of the job and the state entrusted that official to do so. They say in sum, a defendant like Freed must have actual authority rooted in written law or long-standing custom to speak for the state. That authority must extend to speech of this sort that caused the alleged rights deprivation. If the plaintiff cannot make this threshold showing of authority, he cannot establish state action. And for social media activity to constitute state action, an official must not only have state authority, but he must also purport to use it. State officials have a choice about the capacity in which they choose to speak. They say that generally a public employee purports to speak on behalf of the state while speaking in his official capacity, or when he uses his speech to fulfill his responsibilities pursuant to state law. If the public employee does not use his speech in furtherance of his official responsibilities, he is speaking in his own voice. The court asked us to consider a hypothetical from the offline world. A school board president announced at a school board meeting that the board had lifted pandemic-era restrictions on public schools. The next evening, at a backyard barbecue with friends whose children attend public schools, he shares that the board has lifted these pandemic-era restrictions. The former is state action taken in his official capacity as a school board president, while the latter is private action taken in his personal capacity as a friend and neighbor. And while the substance of the announcement is the same, the context, an official meeting versus a private event, differs. He invoked his official authority only when he acted as school board president. The context of Freed's speech, the court say, is hazier than that of the hypothetical school board president. Had Freed's account carried a label that said, for example, "This is the personal page of James R. Freed," or a disclaimer that said, "The views expressed are strictly my own," he would have been entitled to a heavy, though not irrebuttable, presumption that all of the posts on his page were personal. And markers like these give speech the benefit of clear context, just as we can safely presume that speech at a backyard barbecue is personal. We can safely presume that speech on a personal page is personal. Of course, absent significant evidence indicating a post is official. Conversely, the court says context can make clear that social media accounts purport to speak for the government. For instance, when an account belongs to a political subdivision, such as it belonging to, like, the City of Port Huron Facebook page, or it is passed down to whomever occupies a particular office, such as a Twitter account for the Port Huron city manager. Now, Freed's page, however, was not designated either personal or official, which raises the prospect that it was mixed use, and it was a place where he made some posts in his personal capacity and others in his capacity as city manager. Now, the court does go on to stress that an official cannot insulate government business from scrutiny by conducting it on a personal page. And during the oral arguments for this case, the Solicitor General offered the particularly clear example of an official who designates space on his nominally personal page as the official channel for receiving comments on a proposed regulation. Because the power to conduct notice and comment rulemaking belongs exclusively to the state, its exercise is necessarily governmental. Similarly, a mayor would engage in state action if he hosted a city council meeting online by streaming it only on his personal Facebook page. By contrast, a post that is compatible with either personal capacity or official capacity designation is personal if it appears on a personal page. They say that categorizing posts that appear on an ambiguous page like Freed's is a fact-specific undertaking in which the post contents and function are the most important considerations. In some circumstances, the post content and function might make a plaintiff's argument a slam dunk. Take a mayor who makes the following announcement exclusively on his Facebook page, and they say, quote, "Pursuant to Municipal Ordinance 22.1, I am temporarily suspending enforcement of alternate side parking rules." The post expresses invocation of state authority and its immediate legal effect, and the fact that the order is not available elsewhere does make clear that the mayor is purporting to discharge an official duty. If, by contrast, the mayor merely repeats or shares otherwise available information, for example, by linking to the parking announcement on the city's webpage, it is far less likely that he is purporting to exercise the power of his office, and instead, it is much more likely he is engaging in private speech related to his public employment or concerning information learned during that employment. Now, the court says that hard to classify cases require awareness that an official does not necessarily purport to exercise his authority simply by posting about a matter within it. He might post job-related information for any number of personal reasons, from a desire to raise public awareness to promoting his prospects for re-election. Moreover, many public officials possess a broad portfolio of government authority that includes routine interaction with the public, and it may not be easy to discern a boundary between their public and private lives. Yet these officials, too, have the right to speak about public affairs in their personal capacity. Lest any official lose that right, it is crucial for the plaintiff to show that the official is purporting to exercise state authority in a specific post. And when there is doubt, additional factors might cast light. For example, an official who uses government staff to make a post will be hard-pressed to deny that he was conducting government business. Now, the court makes one last point in trying to clarify this matter. They talk about how the nature of the technology matters. And it matters specifically in state action analysis. Now, Freed performed two actions to which Lindke objected. He deleted Lindke's comments and blocked him from commenting again. So far as deletion goes, the only relevant posts are those from which Lindke's comments were removed. But blocking him, however, is a different story because blocking operated on a page-wide basis. A court would have to consider whether Freed had engaged in state action with respect to any post on which Lindke might have wished to comment. The bluntness of Facebook's blocking tool highlights the cost of such mixed-use social media accounts, and if page-wide blocking is the only option, a public official might be unable to prevent someone from commenting on his personal post without risking liability for also preventing comments on his official post. A public official who fails to keep personal posts in a clearly designated personal account will therefore expose himself to greater potential liability. The court would find that the state action doctrine requires Lindke to show that Freed, 1, had actual authority to speak on behalf of the state on a particular matter, and 2, purported to exercise that authority in relevant posts. The court says to the extent this test differs from the one applied by the Sixth Circuit, we vacate its judgment and remand the case for further proceedings consistent with this opinion. Now, that's largely the end of my summary of the opinion, but there is one technical but very interesting note in the way the court chose to end this opinion in Lindke. I do want to talk about very briefly. Taking a closer look at the last section we just read, what we see what it says here is to the extent that this test differs from the one applied by the Sixth Circuit, we vacate its judgment and remand the case for further proceedings consistent with this opinion. Now, the reason this is important is that one thing that courts commonly do when they announce a new test that might or might not be consistent with a lower court's opinion is to first vacate the judgment and second, remand for proceedings consistent with the Supreme Court's opinion. Now, this very well might result in the original judgment being reinstated, but the judgment is vacated first and the lower court figures out what to do. But notice that the court does not quite do that here. Here it vacates the lower court's judgment only to the extent that the court's test differs from the one applied by the Sixth Circuit. This leaves us asking, what has been vacated? Is this a partial vacature? That is to say, is the court saying that the lower court's judgment is only partially vacated? Now, it can often make sense to partially vacate an opinion, but I am not sure how the court could only partially vacate a judgment. The Sixth Circuit's judgment was the affirmance of a district court's grant of summary judgment to the defendant. If the court envisions a partially vacated, partially affirmed affirmance, it might thrust us into a puzzle about what exactly is one judicial unit. And this is an interesting topic that has been discussed by a legal scholar, Richard Ray, whose article I will post to on the show notes page for this episode, along with also I'll post to all the relevant documents about this case. Just the court's opinion, the lower court opinions, the docket page, all that kind of stuff. But getting back to the issue at hand here, you know, is this an ambiguous or a conditional vacature? And that is, I take the Supreme Court here might be saying that it isn't actually sure whether the lower court's judgment needs to be vacated because it isn't exactly sure what the Sixth Circuit test is. Or perhaps different justices who joined the unanimous majority read the Sixth Circuit's test differently, even as they all agreed what the test should be. Now, on this view, when the Sixth Circuit gets the case back, they first need to make a threshold judgment about whether their own judgment has even been vacated, and then if the judgment has been vacated, the panel needs to redo the analysis under the new test. Now, I understand how this works, but it does have a funny feature of effectively delegating to the lower court the task of deciding what the mandate of the higher court has been. Now, as a practical matter, that may be perfectly straightforward, but as a formal matter, it seems incredibly odd. And this is something that I have never seen before. And in future cases, ambiguous or conditional vacatures could be really much more interesting and even have the potential for greater mischief making. Now, again, as a practical matter, I'm sure that this will work out pretty straightforwardly on remand, but I wonder whether we will see more, essentially, to the extent that X, we vacate and reverse kind of language included in future opinions. Well, that is all I have for you guys here today. Thank you so very much for tuning in to Legalese. If you would please take a moment for me and do all of those things that help to trigger Al Gore's rhythm. If you liked the video, hit the like button. If you disliked, hit the dislike button. I would strongly prefer you hit the like button, but you're free to make whatever decision you please. Subscribe to the channel so you always get notifications. For example, the Supreme Court coming up this week will be hearing the oral arguments in Murphy v. Missouri, NRA v. Volo, and Gonzalez v. Trevino. So I will be having videos analyzing those oral arguments coming out over the next week. And then also, leave me a comment. Let me know what you thought about this video. I always love getting your guys' opinions on the content of the videos or the topic we are discussing here. And if you would also please just take a moment and share the show with someone, whether you just share this episode out to your social media profile generally, or maybe you just think of someone who you know who might personally find this information interesting or useful and pass it along to them. And if you would help me grow the show that way, I would be very grateful. So until next time, this has been Bob for Legalese, talking about Lindke v. Freed, and of course, as always, Cartago de Lenda Est.